In this case, ATF has essentially just completely rewritten federal law. What ATF has basically said is, we're just gonna say here on a whim that we think you actually are intending for these to be, whether you designed them or made them, we think you did because we want to regulate them. So we're gonna imply that with a rule, hold you criminally liable if you don't register your firearm.
The new ruling from the ATF now says that attaching the devices to pistols is a felony, punishable by up to 10 years in prison. The Congressional Research Office estimates that there may be as many as 40 million devices now in circulation, resulting in a constitutionality crisis manufactured by the ATF by moving the goalposts on millions of Americans. There are no provisions for grandfathering, and many Americans in many states have no options other to effectively destroy their devices or turn them in. I was privileged to sit down with one of the lead attorneys, Lucas Vebber, from the Institute for Law and Liberty, to discuss the case. So you know why you're in here today, but the folks down the lens maybe have a little bit less of an idea. What's going on?
So a couple of weeks ago, the federal government promulgated a new rule purporting to reclassify every pistol that has a stabilizing brace on it as a short-barreled rifle under federal law. This has significant regulatory ramifications for everyday Americans. Up to 40 million Americans, their estimates about 40 million that could be impacted by this. It's a tremendous change and something that most people aren't even aware of.
And let's just kind of quickly set the stage. Are you able to register an SBR in every single state? Is an SBR lawful in every state, or does it only work for certain folks in certain states?
So states do regulate them separately. I don't know the individual laws in every single state, but states do regulate SBRs on their own as well. At the federal level, the federal government requires a tax stamp, a $200 stamp purchase before you can lawfully own an NFA firearm. It also has to be registered in their federal database. And then once you have it, ATF takes the position that only you can fire that firearm. So as the registered owner. So if somebody else wants to shoot your gun, they can't if it's an NFA firearm.
So, of course, as you know, many folks in many different states have no ability to register under this because it's illegal to register. I mean, certain states just non-starter. New York, Illinois, California, New Jersey, just to name a handful. So folks who have these stabilizing braces in these states, which were purchased lawfully, they have no options here. I mean, they just have to throw it out. Is that right?
Yeah, that's correct. And in many cases, they purchased them lawfully. They purchased them with ATF's explicit blessing that these were not SBRs when they were purchased as determined under federal law.
So what has your group, and what group are you part of, by the way?
So I'm an attorney with the Wisconsin Institute for Law and Liberty. We're a public interest law and policy center based out of Milwaukee, Wisconsin.
And what kind of work do you guys do?
So we bring cases to support our mission. Our mission is to advance the public interest in the rule of law, constitutional government, individual rights. Wherever government is overreaching and it's to the detriment of everyday citizens, Will wants to be there to bring that fight to the government.
So you guys, of course, are representing a handful of people now. You're suing the Biden administration. Who else are you suing about the pistol braces?
So we've just named ATF as our defendant. Okay. We have three plaintiffs. They're all veterans who have stood up, taken an oath to defend our Constitution, to defend our country. And they're all now standing up to fight back against this unlawful regulation that ATF put out.
And what specifically is your lawsuit saying that they got wrong, they being the ATF? What kind of remedies you're looking for, just that kind of stuff?
Yeah, so the remedy we're looking for is just to have the rule completely set aside, right? So the federal law allows us, if a regulation is unlawful, it can be set aside. So that's what we're asking the court to do. The reason that we're able to argue that it's unlawful, we make constitutional arguments. So first, this regulation infringes on the Second Amendment rights of our plaintiffs. And secondarily, the rule amounts to lawmaking. It violates the constitutional separation of powers because here you've got federal bureaucrats who are unelected, are not members of Congress, who have essentially rewritten a federal law. Beyond those constitutional claims, we also have statutory arguments under the Federal Administrative Procedures Act. We make statutory claims. For example, when a federal agency decides to change its mind on how it's regulated something for a period of time and change its mind, there's certain things they have to do. One of those things is just acknowledge that they're actually changing their mind. Here, ATF doesn't really do that. In their rule, they go out of their way to say, no, there's a lot of uncertainty. There hasn't been a clear rule that's been in place for 10 years, and this rule just clears up the uncertainty. And we think that doesn't meet their obligation under the law. We also think the rule itself conflicts with federal law. It conflicts with the definition of a rifle because it purports to redefine things that are absolutely are not and cannot be rifles as rifles under federal law. And insofar as it does that, it conflicts with the federal statute.
Thank you very much for sticking with us so far. There's a lot more great content coming up. Please show your support for not only this channel, but also the Second Amendment and the Institute for Law and Liberty. Click like, share this video around, click subscribe if you want to see us to be able to get more interviews like this one, and on with the show.
We filed this lawsuit a couple of weeks ago. Last week, we moved for what's called a preliminary injunction. We're asking the court to set the rule aside while the merits of the underlying legal issue are litigated.
So last week being first week of February, that's when you've asked for the preliminary injunction. And we're going to keep going to the list of all the other great things you mentioned, but that's going to be super important, asking for that injunction.
Yes.
So let's actually tease that. We'll get back to that in a moment, all right? So what are some of these constitutionality issues that you're looking at? How do you feel like the ATF has violated the Second Amendment?
Yeah, so just last year, the U.S. Supreme Court handed down a decision, New York State Pistol and Rifle versus Bruin. In that case, the Supreme Court struck down some regulations that violated the Second Amendment. And in doing so, they said that whenever federal agencies are attempting to regulate firearms, that the Second Amendment is triggered. It's an individual right that you have to possess a firearm. And when they do that, they have to look at the historical regulation of firearms, and they have to explain why the tradition and the history of firearm regulation supports their regulation. ATF didn't do that for this regulation. They simply said, no, pistols with a stabilizing brace are short-barreled rifles. Short-barreled rifles have been regulated, therefore we don't have to worry about going through that analysis. But that's wrong. They missed the step. They have to explain why pistols with stabilizing braces have historically and traditionally been regulated as a firearm under the NFA, and they simply can't do that. So our legal argument is that violates the Second Amendment. It violates what the court said in Bruin. And it should be set aside. I think part of what ATF's position here is going to be is that a pistol brace is just nothing more than a shoulder stock. That's going to be their primary argument. So that, yeah, this particular device was invented in the past 10 years or so, give or take, and became into heavy use over the past decade. But really, it's just a stock, and it's just a stock by another name. And stocks have historically been, regulated, or at least not the stock itself, but associated with a rifle. And that's kind of how they'll try to get there, I assume. But again, it's a little too early for me to be able to say one way or another, except based on what we've seen in their rulemaking document, which is a couple hundred pages long. And they try to set this stuff out. But the primary argument they made in there for why they don't have to do the Bruin analysis is just because they say these are SBRs. SBRs have historically and traditionally been regulated. Therefore, they're dangerous weapons, I think they call them. And dangerous weapons don't fall under the Second Amendment.
And of course, something else that you brought up before was the ATF is claiming that somehow the fact that you have let's just call it a rifle for now, although I hate doing that. But at any rate, regardless of the overall length, regardless of the barrel length, somehow it becomes more lethal or more dangerous.
Exactly.
Can you speak to that at all?
Yeah, I mean, again, that kind of they attempt to sort of make that argument that this becomes a more dangerous weapon, which then in their minds makes it outside the scope of essentially Second Amendment review. But again, I don't think they've met their burden of showing that. I don't think they can meet their burden of showing that. Here you've got millions and millions of law-abiding Americans who own these devices, who use them every day without incident. It's simply ludicrous for ATF to argue that. They will, of course, argue that. I don't think that the argument is a good one. I don't think it's based in reality, and I don't think a judge is going to buy it.
So, of course, what we're talking about here is rulemaking, right? Because the ATF, although they may think they can write laws, but they can't. They're a federal agency. They can write rules. Rules are not laws. These are different. Rules are interpretations of the law, right? Congress will do kind of big picture stuff, and then agencies step in to fill the gaps. But they can step in to fill the gaps without creating new gaps, without creating new lines and so forth. Is that a fair way to understand what we're talking about here?
Yeah, I think so. I mean, I think most people understand that, we see the Schoolhouse Rock video and we learn about it in fourth grade. We know that Congress writes the laws, the president enforces the laws, the judiciary interprets the laws, but there's also this federal bureaucracy that's kind of the fourth branch that's out there that takes these laws that are written and decides to just kind of write some more on top of it. They, in many cases, in all cases, have essentially the same force and effect of law. You're bound to abide by them, or you could be subject to penalties under them. but they're not written by elected officials. They're written by agency bureaucrats, people who have never stood for election, people who no one's probably ever even going to meet or know who they are, and they're accountable to essentially to no one. Congress has some limited oversight powers, but it requires a rather Herculean effort for Congress to get involved and to overturn these rules. In this case, ATF has essentially just completely rewritten federal law. So Congress has said in the NFA and in the Gun Control Act that they're going to regulate rifles. And rifles with barrels less than 16 inches could be could be subject to the NFA. But a rifle is defined as a firearm that's designed, made, and intended to be fired from the shoulder. So you have to meet all three of those requirements. What ATF has basically said is, we're just gonna say here on a whim that we think you actually are intending for these to be, whether you designed them or made them, we think you did because we want to regulate them. So we're going to imply that with a rule and hold you criminally liable if you don't register your firearm.
So you originally sketched out four kind of thrusts what your lawsuit is. We dealt with the Second Amendment, that this is a violation of the Second Amendment. We talked about this as being an overstep of the delegated rulemaking authority. And of course, you and I can disagree with how much delegated ruling authority they should have. Mm-hmm. But we're talking about the fact that, look, this is a clear overstep. And then we talked about statutory claims. Anything else that is the focus of the lawsuit here?
No, those are the primary ways that we are attacking it. So I think we raise all four. They're all sort of in the alternative, but the court could rule on all four of them. Courts generally tend to like to and have a preference for statutory claims. If they can avoid a constitutional claim, they'll rule on that. So kind of determine up to the court to determine if we win on any and which ones we'd win on. But we feel pretty confident about all of them. We think we've pled them well and we've explained them well, and they're all well within the case law and historical precedent.
So for folks who are curious, because I know that there's nerds out there who are going to say, why would a court prefer to rule on statutory? And I can make guesses based on my experience in criminal, i.e., it's just cleaner and simpler for them.
For sure.
Is that the same way?
Yeah, there's a judicial doctrine called constitutional avoidance, where judges will typically try to just avoid, if they can avoid deciding a constitutional issue, they will. If they can just do it on statutory grounds, it's not a requirement. It's not something that they necessarily have to do. Although courts will usually, if they can rule on a statutory issue and avoid reaching a constitutional claim, they always will do that.
Gotcha. So you mentioned before that you filed for an injunction last week, back in early February. Correct. What would that do if granted?
Yeah, so the rule itself is effective as soon as it was published, but it gave what they call 120 days of enforcement discretion. So ATF has said, hey, you can do one of several options to come into compliance, and we're not going to start enforcing this for up to 120 days or making you comply with it. So what we asked the court to do was, before that 120-day period is over, to set the rule aside while the underlying merits litigation plays out. So when you move for a preliminary injunction, you have to show a number of things. The most important one is that you're likely to win on the merits of the case. So it doesn't mean that you're going to win. The court just has to determine that there's some likelihood that you could win on this case. And if the court can determine that and determine that there's irreparable harm, there's other things, the public interest weighs in your favor, then the court can set the rule aside essentially temporarily while the lawsuit plays out, the underlying lawsuit. Many of the other factors for an injunction are essentially met when you have a constitutional issue like this. So it's a little bit of a different analysis. It essentially just comes down to the likelihood of success on the merits, although we argue all of them in our brief. But as a matter of law, what the PI would do was it would say that ATF has to set the rule aside, cannot enforce it at all, just presses the pause button while the litigation moves forward until the litigation is over.
If the judge does grant you the injunction, first off, when would that be? And secondly, would that only be valid for folks who live in the judicial district in Wisconsin that you filed, or would this be valid for folks nationwide?
Yeah, so our suit is filed in the Northern District of Texas. So we have plaintiffs in Texas. We have plaintiffs in Wisconsin. We brought the suit in Texas. In terms of how quickly the judge would issue it, don't know for sure. It's always up to a judge to make a determination as to whether or not the judge will grant it is entirely in their discretion. We would hope that a decision would come fairly quickly after it's been briefed. So we filed our initial PI motion. The federal government will respond to it. I think it's 21 days, and then we'll file a reply to that within 14 days, and then it'll be fully briefed. It'll be up to the court if they want to hear argument on that. The court could have us all come in and argue the motion in person, and then the court will make a decision on it. As to its applicability and how broad it would be, again, that's up to the court as to how far they want to extend it. Is it just going to apply to the states where our plaintiffs are from? Is it going to apply broader? That's actually a really interesting question under constitutional law, legal, administrative procedure nerds throughout the country as to whether courts can issue a nationwide injunction on a rulemaking case like that. And I think it's something that will probably come up in this case.
So how long is it going to take from now? So we're talking middle of February is when we're recording this. How long from now is it going to take, do you think, until this case has resolved one way or the other?
Complete resolution all the way through the courts. I think, depending on what happens on the preliminary injunction motion, if we win or we lose, or if, the government, there could be an appeal after that on the decision to grant or not grant a preliminary injunction motion. That appeal could potentially go, or it would go to the U.S. Court of Appeals, and then it could potentially go to the U.S. Supreme Court. Obviously, they don't have to take the appeal. They could decline to, but that would itself take probably through the end of the year, certainly into the fall. We're talking at the very least, and if the U.S. Supreme Court grants it, it could be into next year. Then, depending on what happens with the preliminary injunction, then the case would go back to the district court and for a merits decision, the underlying merits decision. And obviously, the outcome of the preliminary injunction proceedings will have a significant impact on the merits decision and could, in fact, be determinative itself. In many cases, that happens.
So what you're saying is that, okay, so step one is the court will determine whether or not they're going to grant injunctive relief, i.e., are they going to press pause? And if so, what's the scope of that pause? That will be the first moment where either side can then appeal that to, I think it might be the Fifth Circuit Court of Appeals.
Correct.
Down there.
Yep, it's the Fifth Circuit.
Okay, so that's kind of step one, where in other words, the lawsuit gets put on hold, it goes up to the Fifth Circuit, potentially all the way to U.S. Supreme Court. And then based on how that turned out, and of course, I can imagine the rigorous constitutionality treatment of the issues in play, that may do a lot to shape how the case returns. Because I think what a lot of people get wrong, and I want to make sure people understand this, is, so let's say this goes up in the constitutionality merits to the Fifth Circuit and the U.S. Supreme Court. The U.S. Supreme Court and the Fifth Circuit make some rulings, whatever they do. It's not like the case is necessarily done.
Correct.
Right?
Yeah. It would come back, and the preliminary injunction is just that. It's preliminary relief while the case pens, essentially. So, if we, for example, if the judge was to deny our preliminary injunction motion, we would, presumably very quickly try to appeal to the Fifth Circuit. We would ask them to decide it very quickly because we're under this 120-day window, wherein if that period ends, there's no putting the cat back in the bag, right? Because our clients and potentially millions of other Americans would be subject to the requirements of this rule. And so we would ask for hopefully some relief, before the 120 days to be completely to have some answer by then. But as you said, once the preliminary injunction stuff is kind of done, and that could go all the way to the U.S. Supreme Court. Once that's all done, the case itself comes back to the district court level, the trial court level, and they say, okay, now we've determined that the preliminary injunction is going to press pause on the rule. Will we move forward? How are we going to go forward on this rule? And there could be anything from more motions, more briefings, potentially a trial. There aren't really questions of fact here that a jury would weigh, but that's kind of when that process would go. So it's a very confusing and lengthy legal process, but I think for what most people are going to be interested in would be these preliminary injunction proceedings at the front end. So
your lawsuit is not the only lawsuit that's out there. There's a number of other lawsuits. Do you have a sense for, is everybody doing more or less the same thing? Are there some discrepancies between lawsuits?
The, again, general underlying theme and the relief that's sought, which is setting aside the rule, is a constant throughout all of those suits. So, I think at the end of the day, we're all kind of rowing in the same direction. I certainly can't speak to all of them out there, but, I think as a big picture, a big ticket item, they're all very similar.
You file this lawsuit. Are you going to win?
Yes. No, certainly can't guarantee an outcome, but and never would. But I think we, again, as I said, I think the case law is on our side, the precedent's on our side. I think we put together a very good case, and I hope that the justice system confirms that for us at the end of the day.
What do you want to put out there, or what gaps have I left that you think it's important that folks know?
I think it's just, pay attention to what's going on and coming out of these agencies. This rulemaking document was a 300-page document. It's published in the Federal Register. I think most people don't realize that every single day our government, sometimes multiple times a day, our federal government is publishing an administrative register. Same at the state level. There's a weekly administrative register here in Wisconsin, for example, that tells you what all these agencies are up to. And they're writing laws, and these laws affect your life in the forms of rules, and they affect your life, and they could force you to do things that you don't want to do, and you might not be required to do them. They could be unlawful, and without everyday Americans who are paying attention and willing to stand up and fight back, nobody's going to be able to stop them.